Welcome to the latest episode of International Law Chats, or ILC for short, a podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us at each month for a new episode. I'm Chiara Giorgetti, Professor of International Law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
And I'm Alison Macdonald, a barrister at Essex Court Chambers in London.
And I'm Milena Sterio, a professor at the Cleveland State University College of Law and also managing director at the Public International Law and Policy Group.
We are delighted to welcome our listeners to a special New Year episode of our podcast, where we will be in dialogue with two wonderful guests, Professor Dapo Akande and Ambassador Franz Perrez. Professor Akande is Chichele Professor of Public International Law at the University of Oxford, a Fellow of All School College in Oxford, and co-director of the Oxford Institute for Ethics, Law and Armed Conflict. He's a prolific writer, and I'm sure he's known to many listeners. Among his many accomplishments, Dapo is a member of the International Law Commission, a barrister at Essex Court Chambers. He's also the UK candidate for judge at the ICJ. Ambassador Perrez is an equally exciting guest and our first repeat guest. He's Ambassador and Director of International Law at the Federal Department of Foreign Affairs of Switzerland and lecturer of International Environmental Law at the Faculty of Law at the University of Bern. Prior to becoming the Swiss legal advisor, Franz was the Swiss ambassador for the environment and head of the International Affairs Division for over 10 years, and as such, he negotiated numerous environmental treaties on behalf of Switzerland. Dapo and Franz are dear friends, and I'm delighted to have them as guests. Welcome, and thank you for being here today. Our listeners will hear this episode at the beginning of 2026, but we are recording a few days in advance at the end of 2025. So we thought it would be a good opportunity to look back at 2025 and think about the year and think about the most interesting things that happened in international law in 2025. Dapo, let's start with you. What do you think has been the most interesting, consequential, or important decision, opinion, resolution, or any other kind of developments really that really caught your attention? What is important for your review for 2025?
Thank you so much, Chiara. It's really a pleasure to be on the podcast. I've had the privilege and benefited from listening in the past, so it's nice to be here. And I'm really glad that actually you started with this question of, what's most important or consequential, because I feel that there is some doom and gloom about international law, but it's actually also important to take a moment to reflect on achievements in international law or things that have been consequential in international law, as I'm of the view that actually there's still a lot of important things that are going on. So with regard to your question, perhaps I can cheat a bit. You've asked about 2025, and maybe I can go back just a little bit beyond 2025 and maybe just take the last, 15 months or maybe even 18 months or thereabouts. And I want to speak about participation by states in cases before the ICJ. So in 2025, the court has delivered two important advisory opinions. And if we go back a little bit, the court has delivered three advisory opinions in the last 18 months. On top of that, the case list of the International Court of Justice, the docket, has continued to grow. Now, some people regard that as a negative thing. Some people say, well, this shows that, states and international societies being more litigious. They say that the docket of the ICJ is growing because of problems elsewhere. The suggestion is made that it's because it's been difficult to solve problems, say, in the political organs of the UN, like the Security Council. That's why states are going to the ICJ. But I'm not so sure about that. And if we think, for example, about the period of the Cold War, which is the first 45 years of the UN Charter, the Security Council wasn't working in that period either. But the number of cases before the ICJ wasn't particularly high. States weren't going to the ICJ. And in fact, one can make the argument that actually the political organs worked even worse then than they are now, at least the Security Council. but participation of states in cases before the ICJ wasn't very high. So I would suggest that there's another reason, or at least some additional explanation. And on the whole, I actually think that it's a positive one. And that positive explanation being that actually states, in my view, are more interested in invoking international law now than has been the case before, more interested in having authoritative decisions on questions of international law now than has been the case before. And the reason I decided to cheat and go back a little bit further is not just to talk about the decisions, and actually I don't want to talk about the substance of the decision of the ICJ, but the participation by case or by states in cases before the ICJ. If one thinks that over this period that I'm talking about, the last 15 months or thereabouts, more than half of states in the world have been involved in proceedings at the ICJ. More than 100 states have been involved in one way or another in a case at the ICJ, either as a party in a contentious case, a participant in an advisory opinion, an intervener as a third state. To my mind, that's not just a remarkable fact, that is just astounding. It's the sort of thing that I think if one had told students about this sort of 5 years ago, they would not, comprehend. They would think that you were just living in sort of outer space. But I think that that's actually a positive thing, that states are willing and prepared to do this at this stage. Sure, there are lots of problems. Sure, there are reasons why these cases come, but states still have a choice as to how they deal with these issues. We shouldn't take it for granted that they would choose to resort to legal mechanisms. They didn't in the Cold War, and the problems were still severe. They didn't do that then. So for me, that's quite significant that states are making this choice to use essentially the organs for peaceful settlement of disputes according to law. I think that's an important thing, and that states are interested in the clarification of rules of international law. I take some encouragement from that. So that's my own reflection.
Thank you very much, Dapo. Franz, let me ask you, from your side, and maybe you have a different perspective as a government legal advisor, what caught your attention in 2025, and what should our listeners also pay attention to?
Thanks, Chiara. And let me also begin by thanking you and everybody for inviting me to this discussion. I think it's really an interesting topic to look back at the year or beyond the year, maybe to see what have been the most exciting and important evolutions. I would agree first with Dapo that this strengthened use of force of law is a good and impressive is a good and expressive evolution over the last years or months. They have many times it was criticized. Well, it's the end of international law. States are not complying with international law, and yes, 2025 as well was a year of blatant violations of international law in all different areas. But I would say, along the lines a little bit like Dapo, it was nevertheless a year that has also underlined the continued corrective and guiding function of international law by several areas. For example, well, it has become clear that states are not standing beyond or above international law, even the most powerful ones. So the fact that the peace plan for Gaza, for example, at the end was submitted to the UN Security Council, shows that international law is relevant, and even the most powerful states are not able to implement their policies alone, that they need international community and international law. And this UN Security Council resolution makes reference to international law, that the Internal Stabilization Force, for example, has to respect international law and international humanitarian law. So that is that is a proof of the continued relevance of international law. Another example is also the most recent ICJ advisory opinion on Israel's obligation with regard to the UN and so on, where the International Court clearly says that national security is not a freestanding exception or a green card that allows states just to violate international law and not to follow international law. And it clearly puts limits around that concept of legitimate national security concerns by indicating that first of all, it must have to be used in good faith, and also that, for example, in the area of national security concerns, states can only rely on that when it is reflected in a specific rule of the Geneva Conventions, or when making absolutely clear in the relationship to the UN. States cannot just unilaterally rely on that concept and then deviate from the rules. They have to follow the mechanisms that have been established to resolve disagreements with the UN with regard to respect of the immunity. So I think despite we quite often a very negative perception of international law today, I think that the last year, from an overall perspective, shows that that was wrong. If I would have been asked what has been the most important evolution last year, then for me it would have been advice opinion by the International Court of Justice with regard to climate change. I think this is a really important decision that gives guidance in many areas which are relevant beyond the climate change law and the international environmental law. I don't know whether you want to go me through one of these points or whether you want to continue by addressing also other issues.
Maybe if you would like to give just one point and then we can move on, just because I know this, the climate change opinion has been very interesting. We discussed it already. But if you think there's one particular issue that you would like to highlight.
Well, maybe cheat as well and say, mention the issue. I think one really important issue, the relationship between treaty law and customary international law. The way how the ICJ has addressed that by saying that there is no lex specialis shield that allows you to walk away from international customary law by just having recourse to treaty law. I think that is a very important conclusion. Another one is about the differentiation between states, where you said very clear the status of the developed country is not defined by some list established in the last millennium, but by current situation, the current capacities. I think that is also a very important one. And then also, I think the general approach to say that the due diligence obligation to prevent significant transboundary harm is also applicable to such a complex area like climate change. I think that was really elements that are relevant far beyond the climate change area.
Thank you very much. And in fact, I think it's interesting how you have pointed both, Dapo, in terms of the general system that and the use of the International Court of Justice, and Franz, this idea that in fact the Security Council and the structure that we have created, we can see some positive, both in the general picture and maybe also in specific decisions of the ICJ. So thank you very much for highlighting some of the positive that we've seen and the interesting developments. Now let's open up the conversation to our co-host, Alison, Milena. Do you agree with Dapo and Franz? Is there anything else that you would like to highlight that you think is specifically worth noting? Alison, maybe can we begin from you?
Yeah, I mean, I think my point is almost it slightly combines the points of Dapo and Franz, I think, because I would agree that if there's a sort of, in terms of content, a legal development in the last year that was all, worldwide and hopefully lasting significant, it would be the climate change advisory opinion. But I think what was really interesting, as well as obviously the legal content of that opinion and the very rich declarations and separate opinions that various judges and groups of judges provided as well, drilling down into specific issues rather than the unanimous advisory opinion of the court. I think what I found very interesting in terms of participation was the process, the sheer number of states who participated, around the process, the involvement of civil society, the youth justice movement, which of course was very important in pushing for the advisory opinion request to be made in the first place. And I think we also mirror this, let's not forget, in the equally important, extremely important opinion of the Inter-American Court as well. It's very interesting, very legally rich, fascinating within the Inter-American system of human rights. In the process, they adopted, again, a lot of civil society participation, hearings in various locations, a very inclusive process. And I think it was pleasing to see that level of participation on an issue where, of all issues, all states are interconnected and everybody is affected. There is only one climate, there is only one atmosphere to the world. We all suffer from the effects of climate change. And I was also, bringing it back to the ICJ, I was really I was really interested in how firmly they situated themselves. For example, at the end of the advisory opinion and in some of the separate declarations, how firmly they situated themselves as, quite modestly, as a part of the UN system, working with the rest of the system of international law, and more broadly, the other strands, the scientific, the political will that has to also come together to tackle this problem. So I thought the way that both of these courts reached the results that they did, and the way that they bring their contribution to what is a sort of very complex issue with lots of moving parts, I thought was very interesting and quite heartening.
Thank you. I think it's important in a moment where we do suffer, where international law, we feel that it's been attacked from so many places. I think it's very important to remember how effective it has been, and how, the developments in terms of the ICJ specific decisions and everything else that has been, positive. Also, remember that the main achievements of this year, which, as you all indicated, they've been quite substantial. Milena, how about you? Where would you like? Where do you think the positive is for this 2025?
So, unsurprisingly, I have to agree with Franz and Alison that the ICJ advisory opinion was truly a remarkable development in the field of international law, international environmental law. Not to belabor any of the points that have already been made, but let me just add that what's really extraordinary here is that the campaign to bring this case to the ICJ originated with 27 students from the University of the South Pacific. It didn't originate with a powerful country or a particularly powerful group. It really originated with a group of students who were rightly concerned with the effects of climate change, and in particular, the rising of the ocean levels. What I would also emphasize here is that one of the other reasons that this opinion is quite extraordinary, in my opinion, is that the ICJ found that there are multiple sources of law which impose legal duties on states to prevent transboundary environmental harm, to act with precaution, and to take various due diligence measures to reduce greenhouse gas emissions and to adapt to the adverse impact of climate change. So a quite extraordinary advisory opinion, which really brought together all these other litigation efforts. We had cases pending in the European Court of Human Rights. There was a case advisory opinion from the Inter-American Court. There was the IDLOS, the International Tribunal for the Law of the Sea advisory opinion. And in a way, the ICJ advisory opinion really brought all of this together. And then I would mention one other development that unfortunately is more negative, but I do think it's important for our listeners to understand this. And I would say that is the United States Trump administration imposition of sanctions against the 3 prosecutors and 6 judges at the International Criminal Court. And the reason that I mentioned that this is quite extraordinary is that normally individuals who have been sanctioned by the United States have included folks like Slobodan Milosevic, El Chapo, or Osama bin Laden. And now we have high-level officials at a major international law institution who now belong in that category. And so while that is not a stricto sensu a development in international law, it's a development from the U.S. side, to the extent that the United States is a global powerhouse and plays a significant role in the international arena. I do think it's important to mention it.
Before we move on to our next topic, Chiara, we haven't heard from you. So I want to ask you what you think would be your development that you'd want to mention for 2025.
Thank you. Thank you very much, Alison. I think I will cheat a little bit also, following maybe Dapo saying, just because I would like to mention 2 things. But first of all, I want to say also that I very much agree with what Dapo, Franz, and both Alison and Milena say in terms of the development, in terms of both big picture, in terms of the use of the ICJ and the number of countries that have participated to it, but also more specifically on what the ICJ has said. And in particular, so this is example number 1, I would like to talk about also about the climate change, because I do think that the climate change advisory opinion was very important. And I would like to stress one thing, so highlight one thing that hasn't been mentioned yet. And that is the idea that the ICJ mentioned, maybe at the end and maybe a little in a hurry, but still, that the entire framework on state responsibility applies to climate change. And that I think is very important, because then you enter with that framework, you will have specific obligations by states, both in terms of cessation and non-repetition, but also providing compensation and reparation, including compensation. And I think that is a very interesting, innovative way that the International Court of Justice adopted in that advisory opinion, which is also has been stressed even more by in some of the separate opinion, including by Judge Bandari, who mentioned that maybe Claims Commission might be something that might be relevant there. And so maybe that brings me to my second point. And here I would like to say, so we are recording the episode on December 11th, but I think one of the most maybe interesting developments is going to happen on the 16th of December. So it is kind of a little bit of magical realism, but our listeners will listen to this episode in January. And so on December 16th, and I'm here now in The Hague also for that, because there will be the signing ceremony for the convention establishing an International Claims Commission for Ukraine. And that is, I think, is a very interesting development, because this will follow the register of damages for Ukraine and will be the second part of the compensation mechanism that is envisaged in the resolution of the Council of Europe that says that for the reparation and compensation here that is due to Ukraine, we'll have first a register and then a compensation mechanism, and that compensation, the Claims Commission will be an administrative body that will decide claims for compensation damages. That will decide claims to compensate for damages, loss, and injury caused by internationally wrongful act committed by Russia. And I think this is very interesting, because we have, again, an act, an international organization that will provide, hopefully, reparation for a breach of international law. And so this idea that if there is a breach, then there are consequences, I think this is a very important telling. This is opening for signatures. This is a convention, so it's going to take a couple of months, if not maybe a year or so to enter into force. But I think this is a very significant development.
Well, thanks to Chiara for that. Let me take the mic now for a moment, and I'm going to ask a new question, which is really the opposite of the previous one. So I'm going to ask what our panel thinks was a development that they didn't expect in 2025 and that they don't consider an advancement of international law. So, Franz, let's start with you this time.
Thanks a lot also for that second question. And indeed, there have been some evolutions that are raising concerns. And let me just highlight two of that. One, I think, is the rapid shift or the willingness of many states to move from an international law-based order towards a transaction approach in some areas. If you imagine that we have established an international trading system with clear rules on tariffs and so on, and how easy it was to motivate countries to just let that aside and engage in bilateral talks leading to preliminary instruments just in order to change totally the world of tariffs based on a united transaction approach. That was a surprise to me. I would not have thought that it would be so easy to replace multilateralism as we know it through transactionalism. However, I think it will be interesting how this will continue to evolve, because I'm not sure whether it will be as simple as some think right now, and whether it will continue towards a polarization, the backlash for multilateralism. We always assume that at the end, this multilateral international law-based system is in the interest of each and everyone, including of the most powerful. And that if you start to move away from that, you will have your own negative consequences to bear for that. So it'll be interesting to see whether, for example, the US sooner or later will be harmed even more than the others by this moving away from the international law-based system. And if that would be the case, then that would prove those right who thought, well, this international system has a value even for the most powerful. That was the reason why they also agreed to it. Another evolution in the last year, which I was surprised, was how very positive by many this establishment of the special tribunal on aggression on Ukraine was welcome. I would agree with what Chiara has described before, the moving from a registered damages to a claims commission. That is a slow, robust legal progress towards also strengthening of international law in such situations. However, the special tribunal, as it seems now to be proposed, from my perspective at least, risks to be a significant step backwards. The idea was to establish a special tribunal that could address the crime of aggression by the most responsible for it, because the ICC, because it's very narrow jurisdiction over the crime of aggression, doesn't have jurisdiction here, that a special tribunal should be established. What has now been established is a special tribunal that, for the first time actually, established to pursue and address the crime of aggression, while at the same time granting protection for those who are most responsible for the crime, for the Troika, by accepting that they can use and rely on Troika immunity as long as they are in function. So we established a tribunal that is just not doing what we wanted to do, and we, on the contrary, seem to confirm an approach that puts Troika immunity above international law. Secondly, it's a tribunal that can only act based on referrals of a situation by the Ukraine. So it's not at all independent. On the contrary, it depends on referral from the Ukraine, which means that if the Ukraine would never refer a case to that special tribunal, and that could be the outcome of a peace agreement, for example, that tribunal wouldn't have any work to accomplish. And finally, also by allowing absentia proceedings for lower level responsible, it is also moving away from good international standards that in principle should not have an absentia proceeding. And sometimes realpolitik requests you to do something that is not ideal. But if something that is even worse than suboptimal is then celebrated as a huge progress and pretended that with this we will make a step forward in fighting the crime of aggression, this is something that I think is worrying. I think by just pretending that this is probably a positive evolution, while in fact, from my perspective, it would be a negative one.
I'm going to turn, thanks to Franz for his surprises and some disappointments of the year. I'm going to turn to Dapo now and say, Dapo, what were your surprises of 2025?
Thanks, Alison. And there are two things that come to mind. One of them is actually just echoing something that Franz has spoken about. And the other one is something that's a little bit more narrow, but which I think is reflective of something broader. So first of all, the one that Franz spoke about, which is, the move away from an international order that's based on law and rules to one that is based on transactions. Here, though, maybe I have a slightly different perspective from Franz, even though I agree with that as a general challenge, and I think that that's a big challenge. But I think the way he described it was, he said, many states making this move. So I agree that the challenge is there, but I wonder whether it's many states or whether it's a small number, but some very powerful states, though a small number. So that rejection of an order that's based on international law, both in the trading area, and of course we've seen this in all the trade disputes that arise, and also in other areas, I think that is extremely worrying. But the flip side of it is that I think, but I may be wrong about this, I think that it's still a relatively small number of states, except that these are very powerful states. And of course, we can think of, in the trading context, of course, and other contexts too, we can think of the United States, right? So the trade wars, the tariff wars, and things like that. What I think is hopeful, to switch back again, is that I think probably most states are still conducting their relations on the basis of the normal rules. It's just that vis-a-vis the most powerful, they're being pulled into this transactional type of order. And that's very worrying, and not just in trade, but also, of course, in other areas as well. The second thing that I wanted to point out is narrower, but I actually think indicative of a broader worrying trend. So this podcast is the ILC, International Law Chat. And of course, there's the other ILC, the International Law Commission, which, as Chiara said in the introductions, I'm a member of. So this year, in the International Law Commission, we met for maybe 40% of the time that we would normally meet for normally. And we were only able to accomplish really just a small fraction of what we were hoping to accomplish. Now, maybe in the world of international law, that's something that is not seen as a big deal and maybe has gone under the radar a little bit. And maybe it's a parochial thing because, I'm a member of the commission and we feel it. But I actually think that it's worrying because it reflects two things that are very worrying. Number one thing that's worrying is the bigger picture about the financial and the liquidity crisis facing international institutions in general. And I don't think that this is something that people pay a lot of attention to. The fact that the UN, and not just the UN itself, but organizations like UNHCR, WFP, International Organization for Migration, they are, suffering quite big financial challenges and cuts, which means that their ability actually to accomplish the tasks that we want them is severely undermined. And actually, if that trend actually continues, the future of these organizations that you would have thought of as being secure doesn't look so secure. France, of course, is in Switzerland. The ILC is based in Geneva. And when I was in Geneva in the spring for the short ILC session that we had, I thought the mood was actually quite dire in a city that has so many international organizations with so many people really wondering about, the future of these organizations and their ability to fulfill their mandate. So that's the first thing, which then had an impact, of course, on the ILC. But it's that bigger impact that's worrying. The second thing, actually, for the ILC specifically, is that amongst all of those cuts that took place, now, of course, the ILC is a tiny cog in that kind of bigger picture, but one of the institutions that suffered the biggest proportion of cuts was this institution that's devoted to the codification and the progressive development of international law. And that I actually found very worrying, that even when you now make this choice as to which bits of this international machinery are going to suffer the most, the bit that actually suffered a huge amount was the bit that's devoted to international law. That was also not a good sign in relation to how international law is regarded. So they're sort of small things, but they're very worrying because maybe they indicate bigger challenges facing the international system as a whole. And hopefully not, but at least it's suggesting some kind of deprioritizing of international law in where you make choice. As we all know, where you spend your money is a big reflection of what you value.
Thank you, Dapo. It's very sobering reflection on some of these sort of ripple effects of the funding challenges that are being faced. And as you say, the areas that particularly impact. So I wanted to ask Milena what your surprise of the year was.
Sure. So, first of all, I absolutely agree with everything that both Franz and Dapo have already said. In terms of some surprising events in 2025, I would mention a couple of things that are seemingly smaller events, but I do think that they have much broader implications. So, Franz already mentioned in the context of the Ukraine Aggression Tribunal, the fact that the tribunal will have the ability to prosecute defendants in absentia. There was a development at the ICC in November of this year, 2025, where the ICC held for the first time ever a confirmation of charges hearing in the Coney case, also in absentia. The defendant was not present in the courtroom. And I would argue, I agree with Franz, that these are not positive developments. I know others would perhaps disagree. But I think that the examples that we have from international criminal law about tribunals that conducted proceedings in absentia, and here I would mention the Special Tribunal for Lebanon, that has not been a positive experience. And for all sorts of reasons that have to do with due process rights, as well as other considerations, I don't think it's a good idea for international criminal tribunals to be moving in this direction. And then the second event that I would mention and also highlight its broader implications are the recent airstrikes by the Trump administration against alleged drug boats, narco trafficking boats in the Caribbean and in the Pacific. The negative implications of this is that there is a potential for the development of international law about the use of force, the ways that states can use force against non-state actors, to broaden essentially the legality, or at least the argument in favor of legality of that type of use of force against non-state actors, which I think would be a very, very dangerous development of international law that could be abused and misused by other states. I'll stop here and turn it over to you, Alison.
Well, I'm going to say it's not necessarily a negative at all, but a development that I didn't foresee. Just looking at something that's specific legal event, I didn't foresee 2025 would bring the UK recognising the state of Palestine. That was obviously a discussion, a development that was much discussed back in September. Wasn't just UK, it was other states, including Australia, Belgium, Canada, France, Luxembourg, Portugal. So it was a group of states who took that step in September. That was something certainly that didn't feature in my crystal ball for the year. And I think it was a very significant step legally and politically for those states. And more broadly, obviously, there was a lot of discussion at the time about the criteria for recognition, the circumstances in which that was done. And I certainly thought, for me, that was if you'd asked me at the start of the year, would the year see that step being taken by the UK, for example, then I wouldn't have seen that arising. So I think that shows also that a year is quite a long time in international law in terms of how things can develop and how long-held positions by states sometimes then adapt to changing circumstances. Milena, over to you to ask the next question.
Can I interject just very quickly before we move on? Because I think it's very interesting, Alison, that you find it surprising. I love the idea that you don't only have to look at kind of the negative thing, but also the surprising thing. So I really thought that was a very, very kind of take on the question, because it's not only positive, but it's also this is very innovative. What is happening there? But if I may reply also to the question before we move on to Milena for the next issue. Because I just want to build on what has been said already, if you don't mind, just because I think maybe to conclude on some of the issues that have been asked before in terms of, for example, some of the surprising events and this idea of the erosion of the post-World War II, maybe legal order that both Franz and Dapo mentioned in terms of how surprising, maybe to me, what's surprising is how fast it's happening. But I think that Dapo is also very right in saying that maybe what has really changed very much is the changes in US leadership and how that has been maybe surprising. And the other issue that I would also like to point out is maybe the issue that that Milena has also alluded to in terms of maybe the undermining or the changing of our understanding of the norms against the use of force. I think that is very important in terms not only, of course, in the Ukraine-Russia scenario, but also in Israel and the region, around Iran. But also, I think most recently, and I agree with Milena here, the U.S. strikes on boats in international waters from Venezuela on the drug-carrying vessels. I think that is very surprising. But also maybe a worrying development because it would, it changes completely maybe our picture of what is a state actor, what is a conflict, what is a target, and also of course the obligations that countries have when they engage in conflicts. So I think a lot of interesting issues there, and we'll see what's happening. I know there've been a lot of discussions also in the US about what is the right approach and how to make sure that the law is international law is respected.
Can I very quickly just on that one comment on that, Chiara? On one side, I fully agree. On the other side, I think I would not agree if someone would say, well, it's one state who can influence the future evolution of international law. I think what is really important is how the other states react to that. And if the other states make clear this is illegal, then I'm not so much concerned that this will have a long-lasting impact on international law. So more important than what the US is doing right now is also how the international community is reacting. And there, I have the impression, and this is not the first case of blatant violation of international law. You had also the aspect to Tehran. There are many cases like that, retaliation used as self-defense and so on. Normally, so far, the international community is responding. Perhaps not as loud as one would hope for, but at least when I was International Law Week in New York, I had nobody arguing that this would be legal, and everyone had understanding that this is illegal.
Thank you so much. Now it's time to move on to our last set of questions. We've been looking at 2025, but now we're going to slightly switch gears and look at the future. So my question to both of you, Franz and Dapo, is what we should expect from 2026. What are you anticipating as the most interesting or surprising events, consequential event that we will witness? So Dapo, let me start with you. What do you think will happen? If you had a crystal ball, what do you think will happen in international law in 2026?
Oh, wow. Crystal ball gazing. That's that's hard because you might then end up with things that surprise you. So I'm going to stick to things that I know are going to happen, but which I'm anticipating will be consequential. And I'm thinking about two things, actually. So first of all, January 2026, or at some point in 2026 anyway, we will have the International Court of Justice having hearings in the Gambia-Myanmar case. So that is interesting because, a case brought by a state under the Genocide Convention and being brought, in order to seek to enforce obligations erga omnes partes. And the court hasn't had much of an opportunity actually to deal with cases where we're seeing obligations erga omnes partes. And there are a number of other cases coming behind the track in relation to this. So it'd be really interesting to see how the hearings progress and also what the court eventually says, because this is a relatively new development in international law. So that's interesting. Another thing that I think is actually interesting, not on the dispute settlement side, but on the lawmaking side of international law. So I think we've rightly sort of lamented the fact that we've not seen actually lots of sort of new treaties that are sort of grand lawmaking treaties entering into force, being negotiated. But actually, there's some interesting development in that regard. Of course, the BBNJ agreement will enter into force in January 2026. That is significant. That's good news, not just for the actual topic and the actual issue, but also the fact that, we're seeing a treaty, sort of big multilateral treaty, not just negotiated, but actually entering into force. The other thing that will happen in January 2026 around the same time is there will be meetings in the UN regarding a Crimes Against Humanity treaty. So that will start in 2026, and that is also significant. I spoke about the other ILC, the International Law Commission earlier. We've gone now 20 years since a text that was adopted by the ILC was actually submitted to a diplomatic conference and adopted as a treaty. The last time that happened was what then became the Convention on Jurisdictional Immunities of States and Their Property. The Crimes Against Humanity discussions and negotiations, it will be the first time that will have happened in a while. That's positive. And for me, I think actually one of the things that is most significant in our era at this time is really the fact that states have not been able to come together very often to agree on the law. So I spoke earlier about, things that happened, say, in the time of the Cold War. What's significant is that even during the Cold War, we saw big multilateral treaties being negotiated, all the ones we refer to now, Vienna Convention on the Law of Treaties, UN Convention on the Law of the Sea. This was at a time when the world was very insecure, but with all that insecurity, states were able to come together to at least do that, agree on the law. And we've missed that. And I think it's significant that at least we've got the BBNJ agreement. We'll see what happens with crimes against humanity. We hope that that will happen. There's another ILC instrument on protection of persons in the event of natural disasters, which again will go to a diplomatic conference. That will be positive if states are able to sit down again and negotiate these kinds of treaties. So that's what I'm looking forward to.
Thank you, Dapo. Let me turn it over to Franz for your thoughts about 2026.
Thanks. And like Dapo, I would be cautious to take the crystal ball because you might drop it, and that's always bad if you drop a crystal ball. But I think there are I would like to mention three elements where I'm really looking forward to the rules next year. The first relates to sovereign assets of an aggressor. And that will be a really interesting development in international law. I remember in 2023 when a group of professors, including Dapo and Philip Sands, were just publishing this paper indicating, well, you could take countermeasures against an aggressor by freezing and seizing the Russian state assets, which are protected by sovereign immunity. So that was seen as a tremendously radical proposal by some. And now we're moving to that direction with what is happening in Europe with Euroclear. So I think that is really interesting how this will further evolve. And we might move towards a system where it is accepted that some state assets are not protected in such specific cases like aggression from countermeasures. A second area, I think, will be international and cyber. I also hope that next year will help us to advance in that area, namely one very specific area. We have the International Maritime Law Initiative, which was launched by the International Red Cross. And one of these work streams leading to that summit next year is looking at how information and communication technologies have to be applied in the case of international maritime law. And questions like what is a non-conflict that triggers IHL in the case of cyber attacks, for example? These are questions that still need to be resolved. What is an attack? Do you need a physical damage of an infrastructure of a building? Or is the total loss of functionality sufficient to be seen as an attack? Which objects are protected under international maritime law from cyber attacks? So many interesting questions where I hope that we will get more clarity over the next year or years, and we're looking forward. And the third area is that relationship between peace on the one side and justice. This is an area where I think in the next months and also years probably we will have to carefully look at. Let me just show two examples. One is, well, if there's a peace deal between Ukraine and Russia, that would violate some of the fundamental rules, like as you cannot conquer territories through aggression, or that you cannot conclude a treaty when you are under pressure on the one side, and a peace deal that is not just from a more objective perspective, but on the other side, eagerness to have peace. So how will that relationship be played out? Will there be a way found that allows us to move towards peace without giving up justice? Another more narrow example is, well, if you want to hold peace talks that might involve Vladimir Putin or Prime Minister Netanyahu, and against two persons against whom you have an ICC arrest warrant. There seems to be also a conflict. Do you have, as a country where these peace talks could take place, would you have to arrest those who are participating in peace talks? Something that is totally contrary to my understanding of the principle of safe conduct when you are participating at international peace talks. Or will we find a solution that does not create an artificial tension between the two principles? For example, that the ICC would conclude that for the small duration of peace talks, state parties do not have the obligation to implement an arrest warrant. That could be a way forward where the ICC itself contributes towards a solution that does not create an unneeded and unnecessary and artificial conflict between peace and justice.
Thank you so much, Franz. Before turning it over to Chiara and Alison for their thoughts, let me just share the following thoughts for 2026. that have to do with two of the perhaps most significant institutions in international law, which is the ICJ and the ICC. On the ICJ side, in addition to obviously the proceedings that are coming up in January, which Dapo mentioned, I would emphasize that we have a round of judicial elections coming up that many of us are eagerly following, including, I'm sure, Dapo. Good luck there. But also on the ICC side, there has been a ton of institutional turmoil. And as many of our listeners know, there's currently an investigation that's been taking place for the past year or so that involves the chief prosecutor who's currently on leave. And I think many of us are eagerly awaiting in 2026 to see what happens, because I do think that leadership role at the ICC is crucial and has to do, is directly related to the legitimacy of the court itself, and also obviously its ability to function properly. So I am very, eagerly awaiting for those developments in 2026. Let me turn it over to Chiara. Chiara, what do you think? 2020,
Thank you. Well,
what will happen?
Thank you very much, Milena, and my thanks, my best wishes also to Dapo for the election in the forthcoming elections, and also Dapo. I'm also grateful for recognizing our homage to the bigger ILC for our podcast. We are all big fans of the ILC and its work. And in fact, I think one of the development comes from that I'm eagerly anticipating, as somebody already has mentioned in just before, is a negotiation over crimes against humanity treaty that is, a product of the ILC that is beginning to be negotiated, and I think that will be very important also because it's kind of the only treaty that is the only main crime recognized under the jurisdiction of the ICC that doesn't have a treaty by itself. So I look forward to see where are we going after all these, very lengthy initial steps. Where are we going in terms of the negotiation itself? The second thing, very briefly, is I am actually quite interested in see what's going to happen with the advisory opinion on climate change. What are the cases that I think we will percolate? I hear these states or other things that are coming on, and I think it's going to be very interesting because the ICJ, the decision may be seen as, as an opening for possible litigations. And what kind of litigations are we going to see more? Some interstate cases. What are we going to see in terms of both international law, domestic proceedings, and also more specifically the relationship between ISDS, investment arbitration, and climate change. I think there are going to be quite significant developments in the next year, and I'm interested to see where those are going.
Alison, over to you.
Yeah, this is not a specific event, but I think an area which is going to be explored in important ways in the next year and more is something that has been touched on in different ways in our conversation, which is the financial consequences of international law violations. Franz touched on the question of sovereign assets. We're about to see the signing of the treaty establishing a claims commission for Ukraine. There are very fast-moving discussions going on within the EU and more broadly at the moment about the potential use of Russian assets which have been immobilized for the past several years. So I think that's a very fast-moving area, and I think that really there are going to be important decisions taken by states in the next year, the next month, perhaps the next week, in relation to what funds will be potentially available for a claims commission in the future. The same topic of reparations of a different slant, as Chiara mentioned, is very pressing in the climate field, both by severely affected states, individuals, NGOs and others around the world are seeking not only action by states to avert the climate crisis, but also reparation for harms suffered, and also to funding for mitigation efforts around the world by more vulnerable states. And as Chiara said, I'm really interested to see what the dialogue is in the next year and beyond between the ICJ, international courts and tribunals, regional human rights courts, and the domestic courts, where individuals, NGOs, will take the necessarily generalized analysis of international courts and tribunals and seek to apply it in their own domestic circumstances in a more granular way to hold individual states to account, to, if you like, to hold their feet to the bar, to use a metaphor of heat. And I think that dialogue between international and domestic courts is really important and it's really valuable. The international courts recognize they can't solve problems like this on their own. So I think that interplay between these general statements and now taking it back to domestic courts to apply and to look at how the policies and the practices of the individual states stack up will be a really important next stage off the back of the really important advisory opinions that we've seen for this year.
Thank you so much, Alison. And back over to you for some concluding remarks.
Yes, well, very briefly to wrap things up. Huge thanks to Dapo, to Franz for taking the time today to be our guests, sharing their thoughts. It's been a really wide-ranging discussion. I don't think we've been delusionally up, but we have found moments of positivity among all the challenges that the world faces, and I think that's great. Thank you also to Freya behind the scenes for all her hard work editing, organizing the podcast. She does a lot that people don't see, but she is the reason why people can see and hear us each month. I've really enjoyed this conversation, and if our listeners have too, you can join us on the first Monday of every month for more international law chats. So happy New Year, everyone, and happy listening.